Welcome to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin, along with Joe Bankman. Hi, Joe.
Hi, Pam.
So today I want to talk with you a little bit about the First Amendment. And in particular, there's the words in the First Amendment that say Congress shall make no law abridging the freedom of speech or of the press. And, if you read those words, they seem pretty literal, but it turns out that there's a lot going on underneath those words. So even though it says Congress, even though the First Amendment talks about Congress, it's not really just about Congress. It's about all governments inside the United States. They're all bound by the First Amendment, one way or another. So city councils are bound by it. As you may remember, we had a case last year about a city council that had our client arrested. And the Supreme Court said that might be a retaliation in violation of the First Amendment. And then when it says no law, they don't actually mean no law. They mean Congress can't make some laws, or the government can't make some laws about freedom of speech. And when they say speech, they're not just talking about words. They're also talking about pictures and images. So the First Amendment, for example, a famous case, protects violent video games. The First Amendment protects movies. One of my favorites, the First Amendment, not personally, mind you, but one of my favorites, the First Amendment protects nude dancing. And then the question is, well, what kinds of speech can be regulated? And one of the biggest categories of speech that can be regulated is speech that proposes a criminal activity. So if I come up to you and I say, I'll give you $40,000 to whack somebody, that's solicitation of a crime. If I engage in fraud, that's a crime. If I yell fire in a crowded theater, that's a crime. So First Amendment has a lot of important things to say, but it's also something that requires a fair amount of interpretation.
And it's different in different places, right? We have our First Amendment, but what is protected here might not be protected in a lot of other countries, including some that we think correctly are every bit as democratic as ours.
Yeah, so just to take two examples, in the United States, if you make a false statement about somebody, the burden is on you, a false and defamatory statement, a statement that damages their reputation. The burden is on you as the press to show it's true. It's not on, is on the person to show it's false, not on you as the press to show it's true. It's the other way around in England. And one of the most famous First Amendment controversies in American history involved the right of the Nazi Party in the 1970s to march through Skokie, Illinois, which was a town with a large number of Holocaust survivors in it. And in the United States, the Nazis have the right to march. In Germany, for example, there are all sorts of bans on Nazi memorabilia, Nazi regalia, Nazi parties, and the like. And yet we consider Germany and England to be, Great Britain to be two of the leading advanced democracies in the world.
And for us today, that's going to be problematic because we've got internet platforms like Facebook that are available all over the world. So one of the questions we're going to look at today is how we interpret free speech, whatever that means, for the internet when it comes to maybe hateful measures all over the world. Whose laws are going to govern?
Yeah, and it's a really hard question, especially when you come to things that are at the boundaries of what kinds of communications can be prohibited. For example, what counts as terrorism?
That's right. And of course, the internet and its immediacy adds a different level of complexity. Fortunately for us, Pam, we have someone that can walk us through some of these issues and has played a leading voice in trying to figure out what the rules should be. I want to introduce Daphne Keller to our listeners and viewers. Daphne is head of intermediary liability. That's really a mouthful. At the Stanford Law School Center for Internet and Society. Intermediary means internet platforms, I'm guessing, like the Facebook, like the Google. And you would know something about that, Daphne, because you came to the law school a few years ago having worked for Google in their legal team.
Mm-hmm.
I was Associate General Counsel heading up work on intermediary liability, this question of whether you have to take user speech down, and I was the lead lawyer for web search. So I was there for 10 years and saw all kinds of content takedown questions.
So maybe explain what it means to talk about content takedown.
Yeah, so every country in the world has some version of a legal framework that says if you're a platform or an intermediary, sometimes there's content you have to take down because it violates the law. So in the U.S., we have a law like that for child pornography. We have a pretty elaborate notice and takedown regime for copyright. For some other kinds of claims like defamation, we don't. We have immunities for platforms. But most of the world does require platforms to take down things, for example, if somebody alleges they're defamatory. And that's kind of a weird system because it means this private company is deciding whether your speech violates the law. And their incentives, of course, are to assume it does and just take it down.
Which restricts freedom of speech.
Sure.
So can you explain a little bit about the question of terrorism on the Internet? Is there something about the Internet that's distinctive when it comes to terrorist activity, or is it just the same thing in a slightly new package?
Well, I mean, there's something about the Internet that's distinctive for all kinds of communications, right? Things get disseminated very rapidly. They cross national boundaries, as Joe was saying. And that's caused a lot of people to ask questions about whether the rules should be different. Cass Sunstein, for example, has proposed that we should change the rules for when terrorist content gets taken down to take it down even if it's not threatening imminent violence, which is what the standard would be under some existing tests.
So can you explain, when he says terrorist content, what counts as terrorist content?
I think he means content that might cause someone to go out and commit a terrorist act.
That seems extraordinarily broad because, somebody who, for example, is very sympathetic to animal rights and reads something about a laboratory that's doing testing on animals that causes tremendous pain, is that story about the lab likely to incite terrorist content? And if it is, does that mean a platform has the responsibility to take that down?
Yeah, well, I don't want to put words in Cass Sunstein's mouth, but certainly for lawmakers outside the U.S. who've passed a bunch of laws on this recently, they have definitions that seem like they could encompass something like that. And it's hard to know what platforms are supposed to take down.
Now, I should say for our listeners, sometimes we have an inside baseball aspect. Cass Sunstein's a law professor, right? And so this is one of us, and he's held positions in the Obama administration, saying, here's what we ought to do on this. And of course, law professors sometimes are influential, but the EU is a lot more influential. And Daphne, you've written about attempts of the EU to require what Cass Sunstein is recommending.
And then some. So there's a new EU law, the Terrorist Content Regulation, that's very close to being passed. It's not all the way there yet. But it, in some versions, would require platforms to use technical filters to try to proactively figure out which speech is terrorist and take that down. And it enables police to tell platforms what to take down without going through courts, and the platforms have to take it down within 1 hour. So there are a lot of speech issues buried in a law like that.
This is Stanford Legal, and today we're talking with Daphne Keller about the Internet and terrorism. Joe?
Daphne, you're talking about the EU, and they've got these proposals out there. What's the status? Is that law now? Is it going to become law? Walk us through what happens with proposals like this.
Yeah, so it goes through 3 bodies. It goes through the Commission, the Council, and the Parliament, much as our laws go through Senate and the House. And then the 3 versions they pass get reconciled in something called a trilogue process. And that's where it is right now. There's going to be some kind of a law unless something very dramatic happens. And we don't know exactly which of these elements from the other drafts it will have.
So when they tell somebody to take something down, they can be telling a platform to take down things that aren't actually physically located in any way inside the EU space. Is that a problem?
Well, they don't think it's a problem.
I know, but if China started telling companies in the United States what to take down off the internet, I think we'd be a little concerned. Should we not be concerned because this is the EU?
Well, from the EU's perspective, the harm is happening there if people are viewing videos there and are incentivized to go commit violence because of it. And so as they see it, that's a good enough reason to go ahead and regulate. On the question of whether China can tell platforms to take things down, there's actually a really interesting and maybe troubling case on this. Some democracy activists sued Baidu, which is China's biggest search engine, in a U.S. court, and they said Baidu silenced our speech at the behest of the Chinese government, and the court said that's okay. Platforms have a right to do that, even if they're doing what China said, and one of the big reasons they have a right to do that is because the platform's own First Amendment rights let it exercise any kind of editorial judgment it wants.
So when we talk about the EU doing something, I think a lot of people are thinking to themselves, well, that's, they're doing it there, and they can do whatever they want. But one of the things you've said, and I think is implicit in what Pam says, is this could affect all of us because our big platforms, Facebook and Google, aren't going to want to have two sets of content. So if they've got to take something down or they're worried about something in Germany, they might just not show it anywhere.
Yeah, so there are two different things going on. One is government saying, hey, platforms, you have to enforce our laws globally. And that's happening with France and the right to be forgotten and with an Austrian case about Facebook. And they're both before Europe's highest court. But the other thing that happens is that platforms, as you said, just agree voluntarily to basically export speech restrictions from one region to another because it's easier. And that happened with something called the Hate Speech Code of Conduct, which was negotiated between the European Commission and 4 big platforms. And it basically has them put into their terms of service rules drawn from European law and then enforce them everywhere.
One of the things with obscenity law, which is obviously a different kind of law, is in the United States, nothing has been found obscene in the last 30 years, I think, that involves just words. It's all images. So the last time I think something was found obscene that was a book with just words on the page was probably 30 or 40 years ago. Is there a difference about terrorism content on the internet that's speech, that's simply words versus images? Should we be thinking about those things differently?
I wouldn't think there would be a big difference. I mean, there's obviously a difference in the legal question about why it is that the government can suppress obscenity versus suppressing terrorist speech. The concern with terrorist speech is that it's going to lead to real-world violence. And words, to my mind, could do that as well as video images.
So, because that's kind of interesting in the sense that I think that increases dramatically the kinds of things that are likely to be subject to suppression, that it's not just training videos or recruitment videos, but it's anything that makes it more likely that someone will become a terrorist. Is discussion of the conditions in some other part of the world enough? Or how are they going to figure out where the line is between discussing political issues and terrorist recruitment or the like?
Well, the European law has a pretty closely negotiated definition of terrorist content, and it's not what ours would be under the First Amendment, but it's careful. It doesn't encompass everything. The problem is it's not courts who will be interpreting that prohibition. It's police going to platforms and then platforms deciding if they're scared enough to take it down or worried about liability or want to just prohibit it under their terms of service. So the breadth of what gets taken down will be way beyond what the law actually prohibits.
This is Stanford Legal, and today we're talking about terrorism, takedowns, and the internet with Daphne Keller. Joe?
Daphne, we've been talking around an issue that Pam raised earlier, which is kind of what are we really talking about here? Can you give us some examples of what's stimulating this? What things do we now see, or did people see on the internet that they won't be seeing under the EU? We understand it might be overbroad, but what's driving this?
Well, I think what's driving this is actual terrorist attacks in Europe and in Christchurch. I think the piece of content that is topmost in mind for a lot of lawmakers is the video of the massacre in the Christchurch mosque, which is something I think that had pretty much universal moral approbation and people saying platforms should take this down. but that under U.S. law, probably there wasn't an obligation to take it down.
I mean, it's kind of interesting because the filming at Christchurch is what you might think of as contemporaneous and retrospective rather than recruitment. I mean, it might encourage others to do the same thing, but that strikes me as a slightly different problem than, training videos, recruitment videos, how to build a bomb videos. This is depiction. If would it have been the same if there had been a news crew standing by who had simply filmed this, or is it because the shooter himself was responsible for the filming?
It's a very good question. I mean, Australia passed a law right afterwards with just 24 hours of public review. And surprisingly, it's not a very good law, but it is about what it calls abhorrent violent content. And it does require that it's one of the people committing the crime that made the content. And the obligations for platforms there are to take it down very rapidly. The executives of platforms risk jail time if they don't. It seems to contemplate some kind of quarantine system for press and researchers to get access to it, but there's nobody responsible for administrating that.
How long was the Christchurch video available for? I can't imagine that. Is it still on the internet?
Must be on it somewhere.
Yeah, I'm sure it's on the internet somewhere. I don't know the exact numbers for the major platforms, but part of what happens is that there are copies on places like 8chan, places that aren't subject to the jurisdiction of much of anywhere outside the U.S. and that are willing to host kind of anything. And so that lets it sort of get repopulated into other places.
But that seems, this law is affecting the major platforms, and the major platforms took it down pretty soon. What?
They moved heaven and earth to do what they could, but nonetheless, people thought it was inadequate.
But that would be true no matter what, wouldn't it? Even if the law is enacted, can the law prevent something getting on the internet for long enough for someone to pirate it and take it out?
No, but the sort of magical thinking about that being possible drives a lot of these laws. And it's to some extent the platform's fault, the big platform's fault. They go to Washington or to Brussels and they say, hey, we're building artificial intelligence that's going to be able to find things and enforce rules really well. And lawmakers are like, great, we're going to pass a law mandating that you do that, which is what the filtering obligation in this EU law is. The problem is the people who study filters say there's some big problems there. They take down the wrong content, and we shouldn't just be assuming that they can be perfected sometime in the future.
Yeah, one of the things you pointed out in one of your interviews that I read was about them taking down human rights violations because it's hard for artificial intelligence to tell the difference between dead bodies in depictions.
Yeah, so there's an organization called the Syrian Archive, and their goal is to document abuses in Syria so that bad guys can be prosecuted eventually in human rights courts. And they had over 100,000 videos taken down from YouTube, presumably because of mistakes that were made by the kind of misidentification you talk about.
We'll be back with more from our guest, Daphne Keller, talking about terrorism and the internet, next on Stanford Legal, here on Sirius XM Insight 121. Welcome back to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin, along with Joe Bankman.
We're here with Daphne Keller. And Daphne, right before our break, you talked about these filters that the big platforms have installed in part to forestall the movements of the EU and other countries such as Britain that are jumping in here, and some of the downsides to that. And you gave one example where the Syrian archives disappeared. Can you talk about that a little bit?
Yeah, so the best known filter for extremist material right now is something called the GIF-CT database. It's administered by the Global Internet Forum to Counter Terrorism. And 13 platforms at least are using it, and it helps them automatically detect and block duplicates of some 80,000 images and videos. And the ACLU and a bunch of other organizations wrote a letter about this a couple of months ago saying, hey, wait a minute, nobody has any idea what these images and videos are. We don't know what the rate of error is. If there's an image that was used in a recruitment video in one context, but somebody used it in news reporting or counter-radicalization materials in another contexts, we don't know if the filters are catching that because filters can't tell the difference between those two things. So there's a lot of filtering going on, and there are a lot of really important questions about what the consequences actually are.
And do we have any evidence that taking things off the internet reduces the amount of terrorism?
It's a really hard question.
How would we even go about answering that?
How would we go about answering it? There was a literature review in 2017 of every Sirius security researcher who had tried to answer that question, and they found pretty much a 50-50 split of researchers saying, we think this will probably help, and others saying, wait a minute, this isn't going to help at all. And the reasons it might not help is driving real terrorists off of major platforms and into echo chambers, reducing the visibility that law enforcement has into the communications that are going on. There are a lot of reasons for concern that even though it makes us feel better to get rid of this content, it's not necessarily making us safer.
And these experts, just to pick up on that, Daphne, they're not saying whether overall it's a good idea or not, because it might impose costs as well. They're just answering the question, will we get more or less terrorism if we do it? And they're splitting 50-50 on the more or less question.
Yeah, that's what's going on. I mean, there are other consequences to worry about here also. So we've talked about the speech consequences and the security consequences. Another consequence that a lot of organizations say they're seeing is disparate impact on people who are mistaken for terrorists. People who are speaking Arabic or talking about Islam say they're being harmed by erroneous over-removals that platforms are doing. And so there's this sort of fairness consequence that goes beyond the speech and security issues.
In contrast, when I talk about tax policy, I'm completely safe.
You are, Joe. You are, at least for now. So when we think about, I think the image in the United States is that what we're talking about here is recruitment videos or how-to manuals. Is that what's going to be taken down, or is there other stuff that is subject to takedown under these theories?
Well, Interpol put out a document a couple of weeks ago saying what they think should have to be taken down under the new law.
What's in that document?
Religious poetry, nonviolent videos.
What do they mean religious poetry should be taken down?
Apparently there is a genre of jihadi poetry drawing on Islamic poetry tradition, and they find it concerning. And
would we have to take down a whole bunch of the Old Testament because it's about God smiting people and floods and past locusts and death of the firstborn? Would we have to take down parts of Exodus?
This is another reason that Islamic rights groups say we think that there's a really unfair double standard being applied here and we are being silenced more than everyone else.
But I take it that I don't want to say defense, but to understand Interpol there, it must be they have some reason to think that that variety of poetry is highly correlated with terrorist messaging of some kind.
I think they do think it's highly correlated. I also think that sort of the nonviolent videos they're talking about are things like recruitment materials saying, come live in the caliphate. It's beautiful. It's wonderful here. There is a logic to what they're asking for. It's just a logic that goes beyond what free expression law would permit here and I think in many other countries.
This is Stanford Legal, and today we're talking with our guest Daphne Keller about what can be taken off the internet in order to prevent terrorism.
Daphne, I want to explore something you talked about a little bit in one of the pieces you wrote, which is a disparate impact not on groups and users, but on platforms themselves. Can small platforms do this, or is this one of these regulations that the only parties that are going to have the wherewithal to do it are the Googles and the Facebooks?
I think it is the latter. I mean, when you pass laws that work because of filters or because of hiring armies of 10, 20, 30,000 moderators, which is what the major platforms are doing, that's not the kind of thing that small platforms can comply with. YouTube, at last count, or at last public disclosure, had spent $100 million on its content filter. That's not something that everybody else can do. So I've had friends from small platforms, and I won't name the platform, say if they really pass this law and we have to take things down in 1 hour when law enforcement in Europe tells us to, I just want to create a portal so law enforcement can come press the button themselves, leave a message so all the users see, it was the London Metropolitan Police that took this down, and get us out of the middle, because we can't realistically do any kind of legal assessment in that time frame.
And when we talk about small users, I mean, this is going out, I think, among other things, on Facebook Live. But suppose I just have a website, and on my website, I have lots of people talking. I mean, Stanford Law School might have lots of stuff on its website. Are we caught in this law?
Yes. It's anybody who hosts third-party content and who meets some jurisdictional provisions, which are, I would say, very likely to reach Stanford Law School.
Well, that's...
I feel I ought to give our dean a call.
Yeah, we need to stop right here and give her a call. But I think, when you talk about the small platforms versus the large, one of the things that in so many other areas of the internet people are talking about trying to do is break up the internet a little bit more so that there's more competition and that everybody isn't going to Facebook or to Google to get their information or their searches. And what you're really saying is these laws may have exactly the opposite or countervailing force and may make it harder to break up the internet because the only people who'll be able to comply and provide a lot of the services will be the largest platforms.
And that's very much what small businesses have been saying about this law. There's a tension between the goal of diversifying expression and expanding competition on the internet by having lots of little platforms and the goal of having some tight regulation that lets you control what speech and content flows through the internet. If your goal or your priority is to control speech and content, you're better off with just a couple of big players. But that's not the internet that most of us value.
So is that in part a product of the fact that there's always been state broadcasting in the EU, so it makes more sense to them to think of this as just another state broadcaster in a way? And in the United States, we've always had the idea of just much more kind of robust competition.
I think there's definitely a connection there. Europe has media regulators that regulate even private broadcasters in ways that are very unfamiliar to us. And there's actually another law, the Audiovisual Media Services Directive, that gives those regulators power over YouTube to tell it to take down content. So the move toward regulators controlling internet content, I think, has a lot to do with that different history.
We've been talking here with Daphne Keller about a law which seems to reflect what we all hope. How can we make sure the internet doesn't foment terrorism? The problems that you've pointed out is that the law can be, as we say in law, over-inclusive. So we can lose a lot of other valuable material without maybe gaining so much in our fight against terrorism.
This has been just terrific, Daphne, and I want to thank you and thank our listeners for joining us here on Stanford Legal on Sirius XM Insight 121. Thanks for coming and thanks for listening.